All right, hello everybody. Welcome to our next lesson here. This is negligence. This is for the year 2019 to 2020. So, objectives and standards. You will be able to analyze negligence under tort law, and you will be able to identify how defenses to negligence are used. And please take a moment there to look at the standards if you would, please. Excuse me, and our desired result. How does negligence apply to tort law? So that sounds like a big question, but what I want you to think about is what does negligence mean in terms of the law? Okay, what does negligence mean? What are some categories that fall under negligence? And then even what are some defenses to negligence as well? All right, so I want you to be thinking about all those things. Tort law and negligence. Society expects certain standards of care from certain people, right? Like you see here is a doctor, right? We expect our doctors to take care of us. We expect, our police officers to take care of us. Things like that, lifeguards, people who have a responsibility, firefighters. We expect people to take certain care in terms of what they are doing, right? When this conduct falls below the standard established, this is known as negligence. Okay, this is a person acts with carelessness, forgetfulness, or a lack of attention. This could even be a construction worker not picking up his tools at a construction site, which we're going to talk about here in a little bit, and somebody trips over it and breaks their ankle. Okay, we expect people to act a certain way in regards to their profession or their care. Okay, some examples of negligence are included below. Again, a doctor forgets to place stitches inside a patient after an operation, and the patient suffers complications. Okay, Mrs. Smith leaves a loaded gun in her closet. Her son finds the gun and accidentally shoots his friend. You might be saying, well, the son is the one who committed the action, but because Mrs. Smith was carelessness and not careful enough and forgetful to lock her closet, and her son found the gun and shot the other boy or the other person, his friend, she could be held as being negligent because of that. A construction worker, we just talked about this, leaves his tools outside a building he is working on. A man trips over them and breaks his ankle. Hannah becomes sick after using a certain new drug to help with her headaches. She later learns the drug company never did testing to find out the side effects of the drug on people. So the company could be negligent as well for not testing the side effects for people. Negligence elements. Plaintiffs or victims need to prove 4 elements in terms of negligence. Okay? One of these is duty. Okay, duty, D-U-T-Y. The defendant or the person responsible owed to a duty or care to the plaintiff. Okay, owed to a duty or care to the plaintiff. I know that sounds a little weird. I'm sorry if it, for any typos there, but it basically means that the defendant, the doctor, the construction worker, the police officer, they didn't do their job. Okay, they owed a duty or care to the plaintiff, and they didn't do that. A breach of duty. The defendant's conduct breached or violated that duty. Did the doctor forget to put stitches in? Did the police officer, forget to, help the person they arrested when they asked for their medicine? And then the person had a stroke or something like that. Things of that nature, right? Again, Mrs. Smith leaves a gun in her unlocked apartment or closet, and her son or neighbor finds the gun and pulls the trigger and hurts himself or somebody else. Okay? They violated that duty to be protecting somebody else. Causation, the defendant's conduct caused the plaintiff's harm. Okay, the doctor not putting stitches in somebody. My mom just had her gallbladder out a couple of days ago, about a week and a half ago, and I know that if maybe the doctor had not had done his job and she had suffered some complications, my mom could have technically sued the doctor for not doing his or her job in terms of taking care of them. And then damages. The plaintiff suffered actual injuries or losses. Again, let's say again my mom's example. Let's say maybe she had she's fine now, but let's say maybe she had some problems. She had some bleeding or something like that, or she was in a lot of pain, and that's because the doctor did not do their job properly. She could sue for negligence to that doctor. Understanding duty and breach. A general duty or a legal obligation to exercise reasonable care towards another person and their property is assumed in society, right? Again, you go in for surgery, you expect your doctor to take care of you and to make sure they're doing the right thing, right? They're not removing, something they shouldn't be removing, right? They know what they're doing, and everything goes okay within reason. Again, I know people become sick and die in operating rooms and things like that, but again, you want the doctor to make sure that he or she and the nurses or whatever are doing whatever they need to do to provide reasonable care. When a person breaches or violates that obligation, the victim may seek damages. Example here, you take your car to a mechanic to fix your brakes. When you pick your car up and try to stop at a red light, the brakes do not work, you crash into the car in front of you, and you are injured. You could sue your mechanic then saying, hey, you didn't fix my brakes, right? You didn't fix them. They're not, you were negligent. You breached your legal obligation, your duty to fix my car. You said you were going to fix my car. You obviously didn't, so I can now seek damages for that. That's a breach of duty. However, not all actions violate duty and breach, right? There's always a but in something. But not everything violates duty and breach. Kevin is swimming in a lake and begins to struggle. Abigail is driving by on a boat but does not stop to help. Okay, she cannot face any legal penalties. Let's say she calls 911, but she doesn't jump in the water to save Kevin. Now, most people would probably try to help the person, right? And I'm sure Abigail, this made-up person I'm making up here, probably may have, or may want to. But if she does not, she can't face a penalty because of that. Maybe Abigail can't swim herself. You can't sue someone because of that. But if Abigail is a lifeguard and she has a duty, an obligation to help Kevin and refuses, then she can face negligence penalties, okay? So again, I used to be a volunteer firefighter. I used to be trained a little bit in CPR training. I'm not anymore, but I used to have CPR training. If somebody was suffering a heart attack at a store or a restaurant or something like that, and I had not, taken it upon myself to help that person, if they were to find out, and let's say the person died or, suffered injuries, I could be sued, okay? I could have been sued because if they were to find out there was someone there trained to give CPR, they could be sued. A couple years ago, another story here for you. A couple of years ago, me and it's my wife now, but she was my girlfriend at the time. We went up to New York City for 4th of July to see a friend and his girlfriend. My friend was riding back on the train with us, and she is a nurse, or she was finishing up nursing school, and there was a person who began to have a seizure on the train platform, and it came over the loudspeaker on the train we were coming home from, that they said if anyone is a doctor or a nurse or has medical training, please report to the train platform immediately. And my friend and a couple other people who I guess were doctors or nurses got up and went to the train platform to help this person. Now, if everybody would have sat down and not helped this person who was having a seizure, those people could have been held for negligence, right? My friend as well, because she's legally trained and she has a legal obligation to go help that person in a medical circumstance. Okay, another example here. Examining causation. A plaintiff must also prove that the defendant caused the harm or damage, okay? Two things must be proven in causation. One, cause and fact. Would the harm have occurred without the wrongful act? Again, my mom having surgery, if she had surgery, would the doctor have forgotten to sew her back up properly or take the right, take her gallbladder out? Would she have, the doctor could have lied and said, yeah, we took your gallbladder out, and, haha, no, we really didn't. My mom has a problem down the road and finds out her gallbladder was not removed or not removed completely and has more problems. That's cause and fact. The doctor acted wrongfully. Proximate cause could the harm, sorry about the typo there, could the harm have been prevented, such as through a foreseeable harm? Again, kind of looking in the future, if my mom wouldn't have went in for the surgery, would this have happened? Things like that. Torts, damages, and negligence. If a plaintiff can prove that the defendant violated their duty with causation, meaning that the person did something that caused this pain or suffering, a court may award damages, right? You see the caution wet floor sign. You might slip and fall in a restaurant or a store, and if they didn't put the sign up to tell you it was wet, you could sue the store or the business for not being responsible and for being negligent. Damages should show the pre-injury or pre-damage status for the plaintiff. So again, if I walk into a store, I don't have a broken ankle, and I slip and fall on a wet floor that doesn't have a sign there, and I break my ankle, well, I show, hey, I didn't have a broken ankle when I went in the store. Now I have a broken ankle and medical bills to pay. Okay, some examples include hospital bills, lost wages or pay from a job, damage to property, such as like in a car accident or things like that. Reduced future earnings if you can't, work or you can't get to work, things like that. Non-economic harm, such as emotional stress. I know my dad was in his car accident. He had some back pain, and that's why he sued the lady who hit him. He couldn't work for a little bit. He had some pain and suffering. Couldn't do the same things he would normally do, so that would be emotional stress. And then permanent physical harm, such as the loss of a limb, or paralysis. The defenses against negligence. Now, there are some times when negligence, can't be punished or penalized, okay? A defendant may be able to raise a valid legal defense to claims of negligence. The most popular form to negligence may be contributory negligence. Example, you are waiting for a train. Okay, let's just say a train. Sorry, but a typo there again. You are waiting for a train, but the platform is slippery. The train station attendant who's selling you tickets tells you to be careful of the slippery conditions. Okay, you ignore the warning. You walk on the ice, with it being wintertime right now, right? You walk on the ice and you slip and fall, injuring yourself. Since you ignored the warning of the train station attendant, you cannot sue for damages, okay? You might say, well, that's kind of tricky. But you decide to walk on the ice, right? You decide to walk across the wet floor. Somebody says, hey, that floor is wet, be careful. And you walk across the wet floor, even if there's not a sign there, you still are responsible, okay? If you see somebody mopping the bathroom in a store or a restaurant, and you decide to walk where that person's mopping, and fall and slip, well, that was your own fault, right? Common sense. You shouldn't have been walking there. Two more here. Comparative negligence. Other examples of defenses, okay? Comparative negligence. Dividing the loss to the degree to which the person themselves is at fault as well. Example, Paul and Javier in a car accident. They smash into each other, okay? Boom. Javier is sued by Paul for $20,000 in damages. However, Paul was not wearing his seatbelt. So, a jury may award Paul only $14,000 for damages since he was irresponsible and was not wearing a seatbelt to protect himself. That's why you gotta wear your seatbelts, guys. Or maybe Paul was on his cell phone and wasn't paying attention as well. Javier can also sue for damages, which is also known as, that should be highlighted and bolded, as a counterclaim or comparative fault. So he can countersue and say he wants damages as well. And the last one here, assumption of risk. When a person is warned of a potential danger but decides to continue with the action. Okay, they decide to continue with the action. Example here, Kelly decides to go for an early morning swim in the ocean. However, there's a sign that says, like you see in the picture here, no lifeguard on duty, swim at your own risk. If Kelly gets injured, she cannot sue for damages since she was warned, but continue to go swimming anyway. Pretty straightforward, right? Don't go and do things. I mean, you can go for a swim in the ocean if there's no lifeguard on duty if you want to, but you're taking that risk upon yourself. They've already warned you. You can't go back and say, well, a lifeguard didn't save me or a lifeguard didn't help me. You were already warned. There was no lifeguard on duty. Okay, closure. Again, how does negligence apply to tort law? Think about breach of duty, duty and breach and things like that. Think about the different things that have to happen for negligence to be applied to law, and even think about defenses to negligence. What can people say to protect themselves from being sued in negligent cases, all right? Have a great rest of your day and night. Please let me know of any questions or concerns, and I hope to talk to y'all soon, all right? And try your best on the questions, everybody. Take care. Bye-bye.